On the night of February 24th, 2022, Vladimir Putin announced an invasion. Immediately it became obvious that his actions are described in international law.
Here is Resolution 3314, one of the most important documents of that law, adopted by the United Nations General Assembly. It contains the definitions of aggression, the invasion by the armed forces, bombardment by the armed forces, and so on. Any sane person could see that Putin's actions check against the definitions. So, is he a criminal in a legal sense?
An international court has to decide that. But what court? Do we have one? And the honest answer is yes, but not really.
Strange, right? Is that why Putin thinks he can get away with all of this? And what has to be done about that?
My name is Anton Korynevich. I am Ambassador at Large of the Ministry of Foreign Affairs of Ukraine. Also, I am a part of a task force. Our goal is to create a special tribunal for the crime of aggression against Ukraine.
The tribunal will be designed for that specific case. It will have the power to indict and try people responsible for the invasion. More than a year ago, over 40 lawyers and political figures called for the creation of a special tribunal. Here's one of them, late Ben Ferenc. He was the prosecutor of Nuremberg International Military Tribunal, the last Nuremberg prosecutor alive. They all agreed on one thing. Right now, there is a gap in the international justice system.
No international court has jurisdiction over Russian officials for aggression. But how did that happen? To explain that, we have to go back more than a century to the origins of modern international law.
The idea of prosecuting the head of state personally for aggression dates back to the First World War. But in the case of Kaiser Wilhelm, it ended with nothing. He just spent the rest of his life in exile. Instead, the League of Nations was created to prevent future global conflicts. The League of Nations failed in this task. The whole world burned. Millions died. On June 26, 1945, the United Nations Charter was adopted. It aimed to mend the world that was broken. Article 2 placed the ban on aggression at the core of the international order. Oh look, there are signatures of Soviet Ukraine representatives in the UN Charter. The United States, United Kingdom, China, Soviet Union, and France got permanent seats at the UN Security Council and the right to veto on any of its resolutions. The Security Council is a key body of the UN. It gets to decide aggression or no aggression. In practice, it meant that the Security Council could pull a brake on any future trials on aggression, and the Soviet Union needed it most. In the meantime, came the trial at Nuremberg. For the first time in history, top officials were personally tried for war crimes. And here's prosecutor Ben Ferenc, who we spoke about earlier. He was just 25 years old. Then, the Cold War dragged on for 45 years and international justice slumbered. A small breakthrough was made in 1974. The United Nations General Assembly defined aggression at last. That's the definition we started with. In 1989, the Cold War ended and international criminal justice was reborn. In the 90s, the United Nations created special tribunals for Rwanda and former Yugoslavia, among others. These were ad hoc tribunals, established for one specific case, and there were no aggression charges.
The world still lacked a permanent international court that could try aggressors.
Finally, such a court was created in 1998, the International Criminal Court. Its powers are described in the Rome Statute. ICC could prosecute state officials, even heads of states, for crimes of genocide, crimes against humanity, and war crimes. But still not a crime of aggression? Why?
Basically, for the same reasons as in 1946. The Security Council wanted to retain its power. Russia was now one of them. It took the Soviet Union's seat.
It took another 20 years to update the Rome Statute. In 2010, it got the jurisdiction over the crime of aggression. In 2018, the jurisdiction was activated. That was a big moment. It took humanity a century of wars and debates and treaties to establish a system that punishes aggression. But that system is still flawed. The jurisdiction was activated only in 2018. That means Putin cannot be tried for the occupation of Crimea and the 2014 invasion on Donbass. And there's also the problem with the full-scale invasion of 2022.
The Rome Statute is written in such a way that the ICC can't prosecute Russian nationals for the crime of aggression without the sanction of the Security Council.
And Russia will never allow that. The International Criminal Court is one of the most important institutions in the world. A distinguished lawyer, Karim Ahmad Khan, is serving there as prosecutor.
Anybody who picks up a gun, anybody who fires a missile, must realize that the law is alive and not in slumber.
Everything we talked about boils down to one fact. There is a gap in the international justice system. We can't prosecute the aggressor neither for the 2014 occupation of Crimea nor the invasion of 2022. The gap has to be closed. That means
we need a special tribunal for the crime of aggression.
Britain's former Prime Minister Gordon Brown proposed to create it a year ago. President Ursula von der Leyen announced the European Commission's support. The European Parliament voted in support of it, and the Netherlands are willing to host it.
All this leaves the most important question: how to establish it? The special tribunal will need a firm basis of authority. We may find this basis of authority within the United Nations or some other way. Ultimately, President Zelensky will make a decision. We are still exploring our options on how it might happen. But it will happen. And it will be a new chapter in the history of international law.